We're very, very grateful to have Reed Genelette as the presenter today. He is a partner at Fisher & Phillips and has been a long-term relationship. Firms have had a long-term relationship with GMA for doing employment claims for GRMA. So with that said, I'm going to hand it over to Reed. Take it away.
Thank you, Dan. And let me kind of expand on what Dan said a moment ago. I think when we initially put together this the schedule for the webinar here, I was with the Ellerbe Thompson law firm. And in fact, I've been with Ellerbe Thompson since 1989. And we merged on September 1st with Fisher Phillips, which is like Ellerbe Thompson is a labor and employment law firm, but they have a national, actually international practice with locations in various states. Both firms originated in Atlanta, and we've had a good relationship with the folks in the Atlanta office for as long as I can remember. In fact, my father was a member of Fisher & Phillips for several years in the 60s. So we've always had a good relationship with them. Our practices have been very complementary. The one thing that Fisher Phillips did not have, however, was a public sector practice, and they were very interested in starting one. And so that really added sort of a bonus to the prospect of our merging. And so I've been co-chairing the public sector practice group at Ellerbe Thompson since 2007, and I am continuing to co-chair it now that it's the Fisher Phillips public sector practice group. And we're going to build it up on a national level, but my focus is going to always be in Georgia. So I wanted to give that explanation for why you may have seen the name change or the change in the name of the firm with regard to my participation in this webinar. The telephone number, the email address, all that still works, although you'll see on the screen there that I've got a new email address that's for Fisher & Phillips. I still receive my Ellerbe Thompson emails if you have that information, and the phone number is the same. So hopefully that will all facilitate a fairly smooth transition. All right. I think Dan may have also mentioned this. I normally like to take questions while we're going, but I'm going to ask y'all to hold them in this instance. And Dan, I don't know that I'll be able to see them when they come up, so I'll ask you to let me know when we get to the questions, and I'll do the best I can to answer them. That being said, it's not unusual for these things to run long and are not being able to cover all the questions that there may be. So what I'd like to do is sort of a courtesy to LGRMS and its members is to, for a couple of weeks, remain available to y'all, via telephone or email. If y'all have any questions that we didn't get to or that may have come up, in the days following the webinar, I will be happy as part of this program to answer those questions for you as best I can. So please feel free to follow up that way. And as Dan said, the PowerPoint materials, which will also have my contact information, will be available in PDF form through LGRMS after the webinar. Okay, well, let's get started. So let me mention from the outset that the goal of the PWFA, or the Pregnant Worker Fairness Act, is to fill in some gaps or some perceived gaps that existed in the prior law. We're going to cover a lot of these, or spend some time discussing these prior laws as well, because I think that helps understand what the PWFA is trying to do in terms of the gaps that it's trying to fill. So we'll talk about that, but just initially about the PWFA, since that's our primary focus in our newest legislation. As you can see, the EEOC has already been very active in pursuing claims against employers. I'm not aware of any claims that it's brought against public sector employers yet, but some fairly high-profile private sector employers have found themselves in the crosshairs of the EEOC with regard to compliance with this particular statute. Now, the act itself went into effect in June of 2023, so a little over 2 years ago, and the EEOC began accepting charges at that time, but they really weren't being processed until the regulations were finalized a year later. So the regulations have been in effect just a little over a year. They went into effect in June of 24. And there's sort of an interesting history there. You know, when an agency like the EEOC issues regulations, they initially come out as proposed regulations, and there's a comment period where stakeholders, you know, primarily the individuals or the organizations whose members would be affected by the regulations, have an opportunity to weigh in and point out some things to the agency that may not have been obvious, or some, frankly, mistakes that may have been made, or things of that nature. And it's kind of a give and take process. And historically, you normally see a good number of the comments and concerns that are expressed by the various stakeholders on both sides, you know, of the equation, get implemented into the regulations, such that the final regulations are often, you know, quite different from the proposed regulations. This matter was a little unique. Again, my focus is employment law, so I really can't speak to how typical this is outside of this context. But my understanding is that it was fairly unusual that almost, even though there were well over 100,000 comments generated by employer groups expressing concerns and asking questions and pointing things out regarding these proposed regulations, they went into effect almost verbatim as they had been proposed. So that's not to say that all of the comments that were received, you know, again, over 100,000, were ignored, but it is a very unprecedented situation to see that none of them ultimately affected the regs as they went into effect. So they knew what they wanted to do, I think, and they weren't terribly keen on deviating from that. And so the regulations that we have as a result of that, you know, reflect that. We don't have much case law on it, as you might imagine. Litigation takes quite a while to run through the process, and only a relatively small percentage of the cases that are filed actually lead to published opinions that sort of form the case law or the precedent that we as lawyers rely on to be able to guide our clients through compliance with these issues, and sometimes more importantly, be able to predict how you know, certain efforts on the part of the employer might be interpreted by the EEOC or by the courts. There's also been a number of legal challenges to this legislation, and a lot of that is focused on the regulations, and they've sort of had various results. I think ultimately some of this is going to have to be resolved by the Supreme Court. Most of the concerns most of the legal challenges that have survived up to this point focus on some of the religious issues that employers are also allowed, at least primarily in the private sector, to you know, to follow, and that relates to largely the aspect of the PWFA that applies to abortion-related services and accommodations. And so we'll have to see what happens with those. But some of the other challenges that you may have read about, such as that the vote to enact the law took place during COVID, when there was sort of the participation was largely by remote access, and there were some questions to whether or not that was the Constitution allowed for that. And a lot of courts said it did not, but I think the prevailing view is that it did. So ultimately, the law itself is probably going to be upheld. The real question is whether these regulations, particularly given how expansive they are going to survive. So we'll have to see how that goes. Let's take a moment to talk about some of the pre-existing law that left gaps in protection that the PWFA was designed to address. And so sort of the granddaddy of all the, or grandmama, I guess, of all of the pregnancy-related legislation out there is the Pregnancy Discrimination Act. Now, this act itself was not passed until 1978, but it is a part of the Civil Rights Act of 1964, and specifically Title VII that we're all familiar with, that prohibits discrimination against various categories, including race and religion and sex, in this instance being the key one. Now, one thing that was sort of interesting was that most of the courts that had looked at pregnancy discrimination type claims that were brought under Title VII were content to equate pregnancy discrimination with sex discrimination for what most people would see as being pretty obvious reasons, that only female employees, at least under the classic interpretation, non-political interpretation, were able to become pregnant. And then in a Supreme Court decision in 1976 called General Electric versus Gilbert, the Supreme Court pointed out that sex discrimination does not necessarily encompass pregnancy discrimination. The point being that males are not the only ones who are excluded from the category of pregnant employees, that there are also non-pregnant females. So you had females on both sides of the equation, and as a consequence of that, pregnancy discrimination was not per se sex discrimination. So 2 years later, we had the Pregnancy Discrimination Act, which was Congress's way of telling the Supreme Court, okay, well, you may have interpreted it technically accurately, but that's not what we intended. We intended for sex to include pregnancy. And so we're now making that explicit. And they did that through this Pregnancy Discrimination Act in 1978. And essentially, this statute, in addition to defining sex discrimination as including pregnancy discrimination, operates to prohibit sex discrimination on the basis of pregnancy, childbirth, or related medical conditions. And this concept of related medical conditions is pretty important. It's going to come back up in an expanded way under the new PWFA. So proponents of the PWFA will point out that the concept of pregnancy-related medical conditions has been around since 1978, whereas critics of the new law would point out that it's a much more broader concept under the new law, and arguably overly broad, which is going to have to be litigated. One thing that's interesting and sort of changed things a little bit under Title VII when the PDA was enacted is that it doesn't require animus. In other words, discrimination based on folks that have a problem with pregnant employees. It also prohibited, what we call these well-intentioned, somewhat paternalistic policies, such as when I joined my firm, we represented a chemical company, and they dealt with various chemicals, some of which were caustic and otherwise known to have an adverse impact on unborn children. And as a consequence, they prohibited pregnant employees from working with those particular chemicals. And interestingly enough, that was determined to be a violation of the Pregnancy Discrimination Act. So that particular employer was trying to be, protective of its pregnant employees, but ultimately the law prohibits, disparate treatment based on pregnancy. It's a form of sex discrimination, and that's what was happening, notwithstanding the lack of any sort of animus towards pregnant employees. So that was a little different. A little bit more about the PDA. Pregnant employees must be treated the same as others who are similar in their ability or their inability to work. So what we're saying here is that we need to ensure that light duty policies that apply to some categories of employees, such as those with on-the-job injuries, they also have to apply to pregnant women or pregnant employees. So to this last point here, and this is probably the most recent, the result of the most recent Supreme Court interpretation of the PDA. A lot of employers, particularly in the public sector, used to fairly routinely distinguish between work and non-work related injuries, and particularly in the public sector, or I should say the public safety area. We saw with a lot of law enforcement officers and firefighters, they might be entitled to paid leave or some additional compensation over and above what workers' comp might provide, or some other accommodations if their injuries were in the line of duty or otherwise work related. And the courts have determined that any practice like that is fine as long as it is applied equally to pregnant employees. They under the law are they don't have to be favored, but they have to be treated as well as anyone else with a temporary disability analogous to pregnancy. So that is one thing that is not intuitive about the law, and we are still from time to time assisting clients with navigating that particular issue. Okay, so that's 1978. We moved to 1991. We have the Americans with Disabilities Act being passed. And of course, this statute, it's well known, protects workers from discrimination based on disability. So that's just classic discrimination, just like Title VII. But unlike Title VII, it goes a little further in that it requires employers to provide a reasonable accommodation to a qualified individual with a disability, at least in the absence of undue hardship or a direct threat. So there's really, there's two primary ways to violate the ADA. One is traditional discrimination against somebody who has a disability as defined by the law. And the other way is to fail to provide a reasonable accommodation to an employee. So that changed things a good bit in terms of classic discrimination legislation at the federal level. One thing I'll point out about this is that pregnancy in and of itself, including really theoretically childbirth, are not in and of themselves disabilities, but there are a lot of pregnancy-related and childbirth-related complications that could rise to the level of the type of physical impairment that meets the definition of a disability under the ADA. So it is in the mix there. One thing to bear in mind, and this has been the law for most of the time that the ADA has been in effect, is that impairments that are protected under the ADA could include not just the pregnancy-related physical impairments, but also mental or emotional related impairments. Could also trigger the protections of the ADA and trigger the accommodation requirement for employers. Now, this is where one of the gaps exists that the PWFA was ostensibly enacted to fill. The PWFA fills in the gap when a pregnant worker needs accommodations, but the condition itself does not qualify or does not necessarily qualify as a disability under the ADA. So it's not to say that this ADA analysis is no longer relevant, but I guess its relevance has been significantly impacted by the fact that the Pregnant Workers Fairness Act provides protection for pregnant workers irrespective of whether they meet the definition under the ADA being disabled. All right, so from 1991, we go to 1993 with the Family and Medical Leave Act, which specifically addresses and covers pregnancy and childbirth. Unlike these other laws that we've talked about, it is enforced by the U.S. Department of Labor, not the EEOC. And another important difference there is that employees that want to challenge whether or not their rights under the FMLA have been violated are not required to go through the Department of Labor for that purpose. So there's no administrative remedies that have to be exhausted through the Department of Labor like there is under Title VII and the ADA with respect to the EEOC. And you have to file a charge and go through that process and receive your right to sue notice and all of that. None of that applies in the context of the FMLA. Now, one thing that I'll say as an aside with regard to the FMLA that makes it a little different in the public sector is that the FMLA applies to all local governmental entities. It doesn't matter how many employees they have. The statute itself applies just by virtue of the fact that you're a governmental or a local governmental entity. What is the same as we see in the private sector is that the rights or the leave and the employment or position protected rights that employees have under the FMLA still require that they be one of 50 or more employees of the employer, or at least work within 75 miles of that number of employees. So that still is there, although it's articulated a little bit differently in the public sector since we all are covered by the statute. That ultimately what that's going to mean is that there are certain requirements for personnel policies or handbooks that we have to comply with, even if we don't have sufficient employees. Where any of them would have any leave rights under the FMLA, we still have to follow the FMLA's requirements regarding that, and with respect to posters. And there are likely a couple of other technical aspects of the FMLA that we have to focus on, notwithstanding the fact that we may not employ enough employees to be covered, well, for them to be covered. But like I said a moment ago, the FMLA, unlike the ADA, the FMLA actually does specifically cover pregnancy and childbirth, as well as adoption, which is a little beyond the scope of this particular presentation, but something that was taken into consideration regarding the importance of bonding with a new child, whether a child that's adopted or born of the employee. So again, what we're looking at here is the FMLA provides eligible employees up to 12 work weeks of unpaid leave in a 12-month period for reasons that include caring for a newborn child, the baby bonding I mentioned a moment ago, caring for a spouse, perhaps a pregnant spouse or a spouse that's recently delivered a child, if these qualify as a serious health condition, eligibility is in addition to the 50 employee threshold I mentioned a moment ago, requires that the employee have worked at least 1,250 hours in the preceding 12-month period. And so the perceived gap left by the FMLA that the new legislation, the Pregnant Worker Fairness Act, is intended to fill is that the FMLA does not cover leave during pregnancy unless there is a serious health condition being experienced by the parent during that period of time. So just the fact of pregnancy in and of itself does not trigger leave entitlements under the FMLA. There has to be that additional showing of a serious health condition. That is not a prerequisite to the possible entitlement of leave under the new law. Okay. More recently, We've seen the enactment of the PUMP Act, which stands for Providing Urgent Maternal Protections for Newborn Mothers. I guess they left the N and the M off of the acronym there. And this was actually enacted as part of the FLSA, interestingly enough, which means it's also subject to enforcement through the Department of Labor, just like the FMLA, but also like the FMLA, there's no exhaustion requirement through that agency, like we would see with an ADA claim or a Title VII claim in the EEOC. And so the Federal Pump Act requires unpaid, certainly can be paid, but and we'll talk in a moment about what Georgia requires, but under the federal law, paid or unpaid leave, break time for an employee to express breast milk if the employee is nursing a child for 1 year after the child's birth, and that break time entitlement is triggered each time the employee has a need to express the breast milk. So that's going to vary from employee to employee. And like a lot of the legislation that we've seen at the state level as well, this particular law required, when first enacted and still maintains, that the employer is obligated to provide a place other than a bathroom for the employee to express milk that's shielded from view and free from intrusion of coworkers and the public. We'll talk in a moment about how the PWFA expands pretty significantly on that particular requirement. And again, as I mentioned a moment ago, the general rule under the Federal Pump Act is that the breaks that are taken by the employee based on her need to express milk are unpaid breaks unless the employee is not completely relieved of work. And the best example of that is if they're still answering telephone calls. Perhaps the room that's designated for expressing milk has a phone in it, and it's a receptionist or somebody that answers the phone for a department head. Calls are redirected into that room during that break, and the employee takes the calls. Then that break is not going to be allowed to be unpaid. And of course, most employees are entitled to a certain amount of regularly scheduled break time. And if that's what's being used by the employee to express milk, then just like any other employee, that would be paid. And as I mentioned a moment ago, the number of breaks that would be needed is going to vary by employee to employee. So there's no limitation on how often the employee can take these breaks. But that being said, there is this built-in protection, for lack of a better word, for employers with less than 50 employees who are exempt from this requirement if they're able to demonstrate an undue hardship. That burden is going to be on the employer, and we always caution them that it is it's a high burden to meet because of the nature of the legislation. And so any employer, private or public sector, that's going to attempt to show an undue hardship with compliance with the Pump Act is going to really have to have its ducks in a row. And I would urge any of y'all to reach out to your counsel, particularly if you have labor employment counsel. Those of you that are in GRMA can contact the GRMA helpline, and we'll be happy to work through that. Let me see here. Okay, I think that covers that. Let's move over. Okay, now there are a couple of other points here that the Pump Act was amended in the last few years to impose some additional requirements, and that is that you do have to provide notice prior to suing under the Pump Act if the nature of the suit has to do with the employer's failure to provide the appropriate amount of breaks or to provide a private location for expressing milk. There's a little grace period you sometimes see in employment contracts that allow the employer a reasonable amount of time, in this instance 10 days, to bring themselves into compliance before they can be sued for those types of violations. The theory being that not every employer is fully aware of its obligations under this law, or that whatever efforts they've made are sufficient. And so this is designed to allow employers to address those issues without being sued. There are exceptions to this notice requirement, and that's when it's an employee claims that she's been terminated for requesting a break under the Pump Act, or for any employee, frankly, that's fired for expressing opposition to how an employer is allegedly treating a pregnant employee under the Pump Act, but the employer is failing to comply with its obligations under the Pump Act, that sort of thing. If the claim that's going to be asserted under the statute is based on that type of a theory, then there's no 10-day grace period for the employer to bring itself into compliance. There are also expanded damages available now under this law. The law used to be limited to the type of relief that was available under the FLSA, but now there's a broader range of damages and other types of relief that are available under the statute as a result of amendments that went into effect about 2.5 years ago, April of 23. Okay, I will mention that there are some resources available on the Department of Labor's website that y'all might find useful relating to employers' obligations under the Pump Act. For example, this door tag, which I've put on here sideways to get it on the screen, can be printed off and used for, look, if you're using an office as a temporary room to accommodate pumping, that right there will come in handy. There's also, I wanted to point out, this is not something that the Department of Labor is involved with, but there are a lot of private sector companies that have kind of gotten involved in the trying to provide resources for employers that are having difficulty accommodating the requirement that that a lactation room be provided. We've seen these sort of things in airports, but a lot of employers that just aren't otherwise in a position to make a qualifying space available have used these types of pods. This one is manufactured by a particular company called Mamava. I'm not sure if I'm pronouncing that correctly. I don't own stock in that company. I just picked them because it was the clearest image, I think, of something that would meet the federal standards. Going back to the resources that are available on the Department of Labor's website, there's a poster that can be downloaded and used to ensure that employees understand their rights under the particular law. This is something that is not explicitly required. The more traditional poster that includes various other rights under the various federal statutes will suffice in terms of the employer's poster obligations, but this provides a little bit more information. Okay, let's shift over to Georgia law real quick, specifically Charlotte's law. This statute, when it was enacted, got split into two different portions of the Georgia Code for codification purposes. So as local government employers, we're going to want to look at the one that's in Title 45, specifically 45-1-7, which applies to us in the public sector. And whereas the prior law that was in place before Charlotte's law only required reasonable unpaid break time, and it really was just the barest of gestures of acknowledging the importance of breastfeeding generally, but the need to express milk during the workday. So the prior law only required reasonable unpaid break time in a private place to express the milk as needed, specifically excluding restrooms from that, and limiting that obligation to 1 year after the birth of the child. So Charlotte's Law makes some key changes to that. Since this has been in effect, it still requires the break time as on a reasonable basis, but now it's paid break time. And the location has to be a safe location near the workspace to express milk as desired. So, you see where we've emphasized through underlining the difference in the two statutes. The old one talked about as needed, the new one talks about as desired. I don't know in practical terms what the difference is between those two concepts, because they probably overlap a great deal, but it is now clear that employers don't need to be getting into whether or not someone really needs to express milk at a particular time, because as desired pretty well eliminates any, the term as desired eliminates any questions about who decides when it's time for an employee to express milk. So again, this is paid break time, and this is interesting because this is a requirement that is going to apply, notwithstanding the fact that there's federal law that governs this same issue, and it doesn't require that the break time be paid. Normally, when you have federal and state legislation that cover the same thing, you often see the federal law preempting the state law. But in this instance, because the state law is providing additional protections for the employee, it still applies. And therefore, in Georgia, notwithstanding the federal requirement that it be unpaid, subject to a couple of exceptions, Georgia law requires that the break time be paid. And then the as desired and safe location are additional differences. The payment's got to be made at the regular rate, and it can't be subtracted from the accrued paid leave of the employee. And the 1 year time limit has been removed, which is also very interesting because, again, it varies greatly from person to person, but some women are able to and desire to express milk long after 1 year. And so that's a significant change as well. Further regarding Charlotte's Law, the right to paid break time does not apply when the employee is working remotely or working or traveling. The presumption being that they're able to sort of self-accommodate in those situations. There is an undue hardship exemption in the overall statute, but it does not apply in to the public sector. It's a private sector exception only. And as I mentioned previously, it's something that we caution our private sector employers about because it's a difficult standard to meet. But in the public sector, in lieu of this undue hardship exemption, there is some additional protection that the local government employers have that are not available to the private sector counterparts. And that is that public sector employers can avoid liability under Charlotte's Law by making reasonable efforts to comply with it. And as of yesterday, I was unable to find any court decisions or attorney general guidance or anything of that nature shedding any light on what reasonable efforts are. But I think ultimately it's going to acknowledge that some local government employers are just going to have a really difficult time, probably in the nature of an undue hardship. I don't want to use that phrase since that provision is not technically applicable in the public sector, but for those that frankly just do the best they can with limited resources and whatever other limitations might apply in a given instance, are going to be protected from liability under Charlotte's Law. Although frankly, I don't know that would be something that everybody would view equally. So we may see some litigation under that before too long. It's just that that particular provision has not been present in the statute long enough for it to be challenged, at least in a decision that's gone far enough to be published and available to guide us as we look at precedent to figure out the direction the stuff is going in. One thing I do want to reemphasize is that almost every resource that I've seen out there that is designed to provide guidance, FAQs and that sort of thing for employers with regard to Charlotte's Law is under the private sector version of the statute. So I encourage y'all to file away in the back of your heads that this particular law does apply somewhat differently in the public sector, and that what you're looking at may actually not be designed to address the specific context of public employment. Okay, so the last state statute that has some arguable relevance to this concept of employee pregnancy-related rights is a statute that doesn't enjoy a name that I'm aware of, but it's codified in Title 31 of the Georgia Code, Official Code of Georgia, annotated Section 31-1-9, and it is a statute through which the legislature has recognized the right of a mother to breastfeed the baby, her baby, in any location. So this is a little different from the Federal Pump Act and a little different than Charlotte's Law in the sense that it's not referring to expressing milk, into a bottle or other container to feed the baby at some subsequent point in time. This is actually breastfeeding. This statute is also not an employment-related statute. It has potential application in the workplace, but it is a statute of general application. So it's broader than Charlotte's Law, and there may be instances where it conflicts with Charlotte's Law. And no obvious examples come to mind, but in the rule under Georgia law and probably the law of most jurisdictions is that when you've got you've got two conflicting laws, and one is a specific law, like in this context, Charlotte's Law would be specific in that it applies to the workplace and applies to the employer-employee relationship. It would control over any conflict that it might have with a law of broader, more general application. So in the event of a conflict between Charlotte's Law and this OCGA Section 31-1-9, Charlotte's Law is going to almost certainly prevail. But this particular statute, it recognizes the right of women or mothers to breastfeed their babies in any location, so long as the mother and the baby are otherwise authorized to be in that location. So, taking this specifically into the workplace, the mother may be authorized to be in the workplace, but the baby not necessarily. But there are public areas of most workplaces, particularly in the local government context. And so this would probably apply and entitle an employee, not as an employee, but as just a resident of Georgia, subject to the protection of the statute, who's otherwise taking a break, to breastfeed her baby in the workplace, if it's a part of the workplace that the baby would be permitted to be in. This is an interesting, point of this statute as it applies to Georgia employers, particularly in light of a provision that we'll talk about in a moment under the new federal law, under the Pregnant Workers Fairness Act, which actually contemplates that that women in the workplace will be permitted to breastfeed their children under certain circumstances if the child is located nearby and the caregiver can bring the child to the employee under circumstances where that can be done without creating any difficulties, undue hardship, or dangerous situations. So that's something we're probably going to see more and more of. I have not actually had to counsel a client on the issue of a employee wanting to breastfeed during or in the workplace, but that is an issue that's sure to arise as more people become familiar with the statute. Okay, so let's bounce back to the new federal legislation, the Pregnant Worker Fairness Act. We've talked about all this laws that pre-existed at the federal and state level that ostensibly create gaps or incomplete protection that this particular statute was designed to fill the gaps in. I will say that this is a very, very comprehensive statute, and when the regs are considered, it's extraordinarily comprehensive. And so I think it goes well beyond filling gaps and poses additional requirements that are going to have to be examined in court cases for years to come before we have a really strong understanding of how this particular statute is going to apply. But a couple of basic points to bear in mind as we go forward. The statute covers employees who are affected by pregnancy. So it's, the name might be a little misleading. It's Pregnant Worker Fairness Act, but and certainly pregnant workers are covered by it, and maybe principally the type of employee that are intended to be protected by it. But it also covers employees who are affected by childbirth or related medical conditions. And as I said earlier, this concept of related medical conditions first came up in the context of the Pregnancy Discrimination Act way back in 1978. And again, proponents of this PWFA, and particularly its regulations, say that they're really not trying to change anything in terms of what a related medical condition is, which is debatable given the scope of it as interpreted under the PWFA, but we'll talk about that in a moment. So, obviously the realm of individuals that are protected by the statute include pregnant employees, employees with pregnancy-related conditions, and that includes such things as infertility, and then post-pregnancy related issues such as postpartum depression and other complications that might follow pregnancy. So it's far broader than just pregnant workers. It covers just about any pregnancy-related direct or indirect condition. It applies equally in the private and public sectors to employees with 15 or more employees. So while this is not part of Title VII, it is similar in terms of how who it applies to, who it protects, and what employers are subject to it. All right, let's see here. Okay, so pregnancy, again, we're talking about a statute that is designed to provide protections for employees who are pregnant, who experience childbirth, or who are affected by related medical conditions. So that's three categories. So what we're looking here is pregnancy. We're looking at childbirth, which includes C-sections, I would think somewhat obviously, various complications that could arise from an employee's pregnancy, infertility and infertility treatment, which makes sense if you think about it, but some folks would argue that that's actually not pregnancy and is a bit of a change under the prior law, and it probably is a category that wasn't previously protected, except to the extent that that may have been a disability under the ADA, but this removes all doubt by specifically referencing it. And then somewhat controversially, it includes abortion and related complications. So I think a better way of looking at it is that it applies to pregnancies that don't result in childbirth. So it covers miscarriages, stillbirths, medically necessary abortions, or elective abortions. And it's the latter that is a complication and somewhat controversial. It's led to probably most of the litigation that we've seen out there. And frankly, I think it's led to most of the successful litigation. I mean, ultimately, it's something that the U.S. courts of appeals or even the Supreme Court have to weigh in on, but a lot of the federal district courts around the country have upheld the right of employers that have expressed, at least in the private sector, religious objections to having to provide accommodations for elective abortions, have had some success in bringing those challenges. And as the law relating to reproductive rights has changed in recent years, we've got some states that have outlawed largely abortions such that employees or pregnant women are having to sometimes travel to other jurisdictions for abortions. A question has arisen as to the extent to which employers are required under this law, under the Pregnant Worker Fairness Act, to accommodate that travel for that purpose. And so that's both opened some interesting legal questions as well as raised additional challenges to that. And one thing that's very important to remember as well, and this is applicable to the infertility and infertility treatments, as well as to the pregnancies that don't ultimately result in the birth of a child, whether it's a miscarriage or stillbirth or an elective abortion, is that there are often related mental or emotional issues that arise from those unsuccessful or pregnancies, let's call them, that trigger rights under this particular statute. So we don't want to lose sight of that. Now,
hey, Reed.
Yes,
just
sir.
to let you know, we got about 6 minutes left in the hour.
Okay. All right. Well, let me then take a moment to explain the way the rest of the presentation is broken down for those of you that are going to get the PowerPoint from LGRMS, which I encourage you to do. You know, there's 5 components to this new law, and they're broken down on this particular slide here. The obligation to provide reasonable accommodations for qualified employees for their known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless the accommodation would cause an undue hardship. And the materials alter the order in which these particular components are examined in what we think is a more logical way, which is what I wanted to point out to you. So Dan will have to print these out in color or make them available for printing out in color. You know, what I've done is each slide here that addresses a particular component highlights it in red as to which one is being looked at. So initially we're looking at pregnancy, childbirth, and related medical conditions, and what that means, because there is a tremendous number of conditions that are recognized by the regulations as being covered or as constituting a related medical condition. And this is not even an exhaustive list. Also important is this, the second point that's highlighted here on this slide, which is what constitutes a qualified employee. And so the definition under the ADA applies equally here, which is an employee with a known limitation under the PWFA, that's a pregnancy-related condition, is considered qualified if she can perform the essential functions of the job with or without a reasonable accommodation. But it's expanded upon under the PWFA in the sense that an employee who cannot perform one or more essential functions is still considered qualified for purposes of the PWFA if whatever that essential function is that she's unable to perform, she can perform in the near future. And her inability to perform it is something that can be reasonably accommodated for the period of time during which she is unable to perform it. And so that raises the question of what the near future means. And importantly, the regulations say, well, in the case of a pregnancy, it's the entire pregnancy, which is approximately 40 weeks. So that means the statute contemplates that if an employee is temporarily, because of the pregnancy, unable to perform an essential function, but we'll be able to in the near future. That's a 40-week period there. And so there is still the accommodation requirement. So if it's something that can't be accommodated, then that's a different issue, and that's something you need to talk to counsel about, because it's it can be very complicated. But that's how the regs address the pregnant employees' qualifications. For just about any other thing, it's a case-by-case basis, which is comparable to what we see under the ADA. So, and then also, like under the ADA, the near future is never going to be satisfied by indefinite periods of time. So if the medical provider can only tell you that it's indefinite, and that's the extent of the information that we know in terms of how long it'll be before the employee can perform the essential functions, that's inadequate to trigger the qualified employee analysis. But for the most part, under the current pregnancy, the provider is simply going to say the 40 weeks. So that's a real game changer. And then the materials go on to address reasonable accommodations in various contexts. And then ultimately the undue hardship is the last one. And that, again, is something that we encourage our clients to be very cautious about applying, because there's going to be a tremendous presumption against it. And any employer that is going to pursue that defense to an accommodation request is going to have the burden of proof. And this is an important reason to maintain current documentation, particularly with regard to the position descriptions. And we, even long before this law was in place, we were encouraging our clients to ensure that they update regularly. We say at least every 18 months, if possible, position descriptions, because it doesn't take long for a position to evolve beyond what's written on the paper. And so it's often important to speak to department directors and other managers to confirm the relevance and the accuracy of the position descriptions, because that's going to be an important piece of evidence if we ever have to try to establish an undue hardship defense under the PWFA. So apologies for not being able to get through the entirety of the presentation. Again, I want to make clear that I'll be available for the next couple of weeks, let's say the rest of September, to answer any questions as part of this presentation. Of course, anybody can call me at any time or email me at any time regarding these issues, but just particularly with regard in the next couple of weeks, I want to make myself available to you for this purpose. Dan, do we have any questions that have come in at all that I can address in the next couple of minutes here?
Does anybody have any questions? If again, you can't think of something and it pops up later, we can always see what we can get. But any questions from anyone? Reed, thank you so very much. Great job. Really appreciate it. Again, I will be sending out the recording link and the presentation. You guys all have a great day. Thank you very much, and we will talk to you later.
Thank you. Thank you, Dan.